Good afternoon, everybody. Thank you so much for devoting your wonderful Friday afternoon to this serious topic of climate law and lawsuits for the future. But we are so excited to have a really excellent speaker and another really excellent discussion. So even though it's Friday afternoon, I hope that we will have a very enjoyable Friday afternoon. So I'm really privileged to announce Katalin Sulyok as our guest lecturer today. She is currently a professor at the Department of International Law at the Eötvös Lorand University. She holds a bachelor degree actually in biology, but in parallel with that, quite an amazing thing, already doing a biology MSc degree, and in parallel she did her LL.M, so her master's degree in law, also at Eötvös University, but then she also completed her LL.M, so her master's in law at Harvard University. She was there also a Fulbrighter. Then she immediately started her skyrocketing career. She was the chief legal advisor for the Hungarian Ombudsman for future generations for 7 years. And among all her other feathers, which I don't want to take all your time to talk about, but she was also, and she is also the chair of the Climate Crisis and Human Rights Working Group of the European Ombudsman's organizations. This was the organization who also initiated or was involved with the famous climate case that she will also talk about. So without further ado, I want to pass it over to Katalin. Katalin, the floor is yours, and welcome everybody also to our online audience. We are streaming this also live and will also go on YouTube. So if you have friends who missed it, you can also recommend this to them. Thank you, Katalin.
So welcome, everyone. First of all, I'd like to thank Professor Diana Eötvös for inviting me. It's a real privilege for me to be here today at CEU in Vienna, even though I'm also sad that this talk cannot take place in Budapest, and not because I don't love this beautiful city of Vienna. The title of my talk today is Lawsuits for the Future: Can Litigation Help Ensure a Livable Climate for Future Generations? And we'll be using the upcoming 50 minutes to talk about the challenges and the opportunities of climate litigation, which is a booming and highly creative and heterogeneous field of litigation. And I will argue that using this legal framing, focusing on the interest of future generations, can be a pretty effective legal tool, which will help us tackle, hopefully help us tackle the planetary challenges and crises that we face in this century. So now, unfortunately, all of us know that 2023 has been the hottest year on record, and we just keep breaching temperatures records ever since. But what may offer a glimmer of hope is that climate litigation is also turning up the heat. So in 2021, the famous Federal Constitutional Court of Germany ruled in the Neubauer case, in which these young individuals challenged successfully the federal German climate law for being ineffective and for mandating too lenient mitigation measures. The court agreed with the complaint and argued and found that the German climate law is invalid because it effectively postpones all meaningful mitigation burdens and puts this drastic mitigation burden on future generations because the meaningful emission cuts were mandated post-2030. The same year has seen another major breakthrough, this time from Dutch courts in the famous Shell case, which was the first court which ever ordered a single major emitter, the Shell Group, to cut its emissions. And this opened the door for exploring ways of corporate climate litigation. 2023 has been the year when climate litigation has reached the level of international courts. So the European Court of Human Rights, which is seated in Strasbourg, the famous Strasbourg court, is now hearing 3 climate cases. And one of them is the Duarte case, in which 6 Portuguese children are suing 32 member states, including all 27 EU member states. They argue that the lack of effective mitigation measures will violate their right to life and private life, and this non-discrimination, the prohibition of non-discrimination, because the adverse climate impacts that they will have to endure during their lifetime. In the same year, we've seen another major landmark because the UN General Assembly, for the first time in history, was united enough to request an advisory opinion from the International Court of Justice, which is the chief judicial organ of the UN, sitting in The Hague. This advisory opinion, although it will be non-binding, will be highly persuasive and highly authoritative. So it can be a real game changer because it can influence the reasoning and judgments of other international courts, but even domestic courts. Even though it will be delivered in a so-called non-contentious proceedings, which means that it will not entertain the legal liability of a single state, but it will give an abstract interpretation of states' obligations concerning climate change under international law. Another very significant feature of this opinion is that it does not relate to the well-known Paris Agreement, but it will comment on states' obligations under other major international treaties, such as human rights treaties and the UN Convention on the Law of the Seas, and also under customary international law, which is a very peculiar source of international law. It's a body of unwritten rules which can dynamically evolve. And this will be the first time that a major international court can announce a judgment and it can give an authoritative interpretation of what are the obligations of states under customary international law with regard to climate change. So all of these proceedings are charting unknown territories, and they were pretty much unimaginable 10 or 15 years ago. And now we not only see such proceedings popping up in every jurisdictions, but we also see that they are increasingly successful. And so the remaining roughly 40 minutes, I'd like to really dig a little deeper into the common structure of these proceedings and think about how can they, or in what ways can they bring a transformative change into environmental and climate governance? So I will structure my talk into three main parts. In the first part, I'd like to talk about what I see as the major shortcomings of the current legal paradigm. When we talk about the climate crisis and talk about the need for a rapid transition to a net zero world, we often talk about technologies, right? But we mainly talk about physical technologies, green technologies, physical technologies with which we can decarbonize. But what is often overlooked is how law in and of itself is also a sort of technology. It is a type of social technology. And as such, it has also played a huge role in engendering the climate crisis. And I also believe that it can have a role in abating the crisis if we can come up with innovations in this respect, if you can innovate in law, and if we can restructure the legal paradigm in a way to come up with legal tools which can help us better tackle this crisis. Now, in the second part, I will move on to talk about climate law and what I will call as the shared legal anatomy of these lawsuits, because climate litigation is a very heterogeneous, but I also believe that all these proceedings share some common core similarities. And I think that these similarities really talk about the shortcomings of the current paradigm. So what I believe that climate litigants try to come up with these legal innovations that we need so much. So they try to come up with new ways of interpretations. They try to argue for new ways of obligations. And in a way, they try to change the current paradigm. And in the last part of my talk, I will be talking about the power of using this narrative, which focuses on future generations. And I will explore and argue that the idea of intergenerational equity, the idea that the current generation owes not only moral, but also legal obligations toward the future, carries the potential of bringing about a transformative change. So I will make the case that intergenerational equity is similar to the book that you can see on this picture. Now, many of you may be familiar with this famous installation called The Castle, designed by the artist Jorge Mendes Blake, who put a single tiny book, Franz Kafka's book called The Castle, at the bottom of this brick wall. And you could see how this tiny little vulnerable book could transform the structure of the entire brick wall. So by way of analogy, I will be arguing that the idea of intergenerational equity, the idea that we owe some legal obligations towards the future, can act like this tiny book, and it can transform. It has the potential of transforming the whole legal system, the system of rules that we apply currently. So let me now start with the diagnostic part. What are the problems with the current system of laws? So I believe that the first major problem is short-termism. Short-termism, which is inherent in democracies. Democracies have a myopic bias, a presentist bias. They focus so much on the short term. And don't misread me. I'm not at all claiming that dictatorships would be any better. But I also believe that we who live in democracies have a moral obligation to start to make democracies even better and try to rectify the problems that it has apart from its many benefits. So there is this inherent short-term bias in democracies because democratically elected leaders seek re-election, and thereby they are focusing on the 4- and 5-year-long election cycles, and they try to satisfy and they prioritize the immediate, typically economic gains of their constituencies. And democracies, unfortunately, as of today, children, minors, future generations are disenfranchised, which means that they don't have the right to vote. So they obviously do not form part of the relevant constituency for political leaders. This is why they are often called as the permanent minority, which may not be true in numerical terms, but it is definitely true in the sense that no one is speaking for future generations at the negotiating table, no one's representing future generations at cabinet meetings. And even in states which try to rectify this, and in states which try to create spokespersons for future generations' interests, that can also lead to problems in democracies where the basic idea is that the majority should rule. So when you create spokesperson institutions for future generations, it can raise so-called counter-majoritarian problems, so it can face pushback from the majority. I myself also have been working for the Ombudsman for Future Generations in Hungary for 8 years, and there are several similar institutions worldwide, in Wales, in New Zealand, in several other states worldwide. So states are now experimenting with giving, trying to giving voice to future generations. I also believe that not only democracy is short-termist, but also our rules governing state responsibility. So whereas legal rules work pretty much well with allocating responsibility for harm that has already been caused, or allocating liability for harm which is caused in the present, there is a sort of a liability gap with respect to harm that is inflicted up a longer time scale in the future. And I think that this is one of the major shortcomings. We have to come up with solutions of allocating responsibility for harm that is imminent in the future. In my view, the second problem lies in states' wide margin of discretion, their wide room for maneuver of pursuing their myopic presentist policies. On an international level, states are viewed as sovereigns who enjoy sovereign rights over the natural resources found within their territories. So basically, they have almost unfettered discretion to use these resources. Of course, there are some emerging limits, but the general rule is that they can use them as they deem fit. The second problem, which relates to that, is the ancient-old idea of separation of powers, which means that the judiciary must not interfere with matters that are reserved for the legislature, which will cause special problems for climate litigation, where the core of the question is whether the legislature adopted adequate mitigation targets, adequate GHG reduction measures or not. This confined nature of the judicial review is all the more true for technologically and scientifically complex cases and complex policies, such as environmental policies and climate policies. So in these spheres, we often see that courts restrict their sort of review. They don't want to really look at the merits, the depth, the scientific depth of the questions, because they feel that they don't possess the necessary technical expertise, and they believe that state authorities who pass those legislation, those climate bills, they are better equipped with deciding about the appropriateness and correctness of these measures. So all of these taken together result in a very confined ambit and scope of judicial review in these cases. And I think that the third main problem of the current paradigm is that the present generation believes that we don't owe any legal binding obligations to the future. If anything, these obligations are purely moral aspirations. And this is rooted in the idea of intergenerational equity, which is in fact a very ancient idea. So ancient civilizations, irrigation cultures, all respected this idea that we need to consider the impacts of our present actions several generations down the line. And it and it is part of indigenous legal cultures, but not only these cultures. So maybe it is surprising, but the United States of America itself referred to this idea at the end of the 19th century in the Bering First Seals arbitration, where it argued that it has a legal obligation to pass down its natural wealth to future generations, and this is why it claimed a right to regulate seals hunting on the high seas, where the UK wanted to hunt those animals. Unfortunately, this argument did not fly in court back then, but nevertheless, the principle of international equity, made its way to the cornerstone of international environmental law, the 1972 Stockholm Declaration. And later on, it was referenced in more than 30 international treaties, of course, mostly in the preambular paragraphs and vaguely defined provisions, but nevertheless, it became part of international environmental law and has become a widely recognized principle of international environmental law. The problem with that is that international courts have never deemed this principle to be binding, to be a standalone binding principle, which is justiciable, which means that they never discerned any binding obligations on, and they never imposed binding obligations on states on the basis of the principle. So they treat it as a mere soft principle. But I also believe that if we look at the recently booming field of climate litigation, that we see that courts' approach to the idea of intergenerational equity is now changing. So I think that courts are now becoming more receptive to the idea and the realization that climate change is in fact and in its sense, it's an intergenerational conflict. Because our actions, or more like our omissions, will fundamentally impair the living opportunities of future generations. And I think that they finally start to treat intergenerational equity with the legal high profile and high standing that this idea really deserves. And this comes at a time when the future generations narrative is picked up by states as well. So in the last 10 and 20 years, many states have amended their constitutions to include some form of reference to future generations. So a recent study stipulates that 41% of all national constitutions mention future generations in some form. So meanwhile, at the same time, if we look at climate litigation practice, I believe that we see that domestic courts have started to read intergenerational equity into other binding obligations. So they're still not claiming that the principle of intergenerational equity would be a binding justiciable norm per se, but what they are wanting to do is to interpret other well-established normative binding obligations of states under international human rights law, under tort law, under constitutional law, under various legal sources, and develop a sort of intergenerational dimension for these obligations, and thereby inject long-termism into states' traditionally short-termist perspective. And I think that by doing so, what they're actually doing is that they're enforcing intergenerational equity. I think that this idea is now staging a comeback indirectly. And I think this is the sort of one of the common thread that binds all these very, very different and heterogeneous lawsuits together. So I think that this idea that future generations deserves protection, this is very manifest in climate lawsuits. So let me now address this booming trend, which is really a global phenomenon. So we see such lawsuits coming up in every major geographical regions of the world, every major legal systems. Let me just briefly touch upon the international legal background, because so that many of you may not be lawyers or international lawyers. But we all know the Paris Agreement that we have, which is a binding international treaty concluded back in 2015, which is very significant for many reasons. One of them is that it enshrines temperature target for every state that is signatory to this universal treaty. But it also has shortcomings. Some of the major shortcomings is that there are no top-down mandated binding GHG reduction targets for states. So the basic idea of the Paris Agreement is that all states will submit their own nationally determined contributions, their own NDCs, which will determine the mitigation action that they pledge, that they offer for the international community. Another major shortcoming, if you like, is that there is no judicial mechanism attached to that treaty. So states are well aware that no one will sue them before an international court if they not comply with the Paris Agreement or the temperature goals, for that matter. So this begs the question, are states really free to set their MDCs, their mitigation targets, as they wish? Well, back then, back at the drafting event, or the closing event of the Paris conference back in 2015, the drafters of this agreement may or might have thought so. They had reason to believe that no one will sue them if they are not deliver the temperature targets. But the recently booming field of climate litigation definitely suggests otherwise. So this the wave of successful climate litigation reached Europe with the Lorand decision at the end of 2019, where the Dutch Supreme Court ordered the government to adopt a new climate law and climate plan with deeper and faster GHG mitigation cuts. So that was the latest moment when lawmakers should have realized that they will be able to sue them. They will face litigation risk, not based on the Paris Agreement, and not necessarily before international courts, but before domestic courts, and based on constitutional law, based on human rights law, and as we will see shortly, based on a host of other legal bases that climate plaintiffs have come up with ever since. So with the after the adoption of the Paris Agreement, you see on the top chart how the number of these lawsuits really started to skyrocket, and they are continuing ever since. So this global phenomenon of climate litigation covers, in fact, very different and very varied lawsuits. So it is a catchphrase with umbrella term, which encompasses all sorts of legal proceedings between various actors. So plaintiffs could be NGOs, children, elderly, scientists, or even an octogenaric nun in a case in Australia. And they can sue various people, various entities. First, they sued states, but now we see corporate climate litigation cases. And the newest wave of climate litigation lawsuits are now experimenting with finding ways of articulating individual responsibility of corporate leaders, of CEOs, for not being aligned with the Paris goals. These cases are pending before domestic courts, some increasingly before international courts, and they are rooted in various legal bases. So there are rights-based litigation, which is based in human rights, either domestic or international conventions. There are constitutionally rooted proceedings. There are tort law-based cases. There are some which are rooted in consumer protection laws or the rights of minority shareholders. So they're very, very varied proceedings, and they seek different remedies. They want to achieve different things. So some of them challenge mitigation laws, unambitious mitigations, unambitious GHG reduction measures. Others seek to enforce more adequate adaptation actions. Some challenge and raise the idea that states or emitters, major emitters, should pay for climate damages that they cause. So these loss and damage proceedings. And they're not only more successful in more and more cases, but they also seem to have a material impact. So as this recent working paper suggests, even the launch of such a climate lawsuit will decrease the firm's value with a 0.4 percentage. So that so they can have real life impact, and they can really change not only the legal system, but also how the economy and the corporate sector works. So I will claim now that despite all these variety, there are some shared legal anatomy of these lawsuits. There is a shared legal architecture. There are some structural similarities between these lawsuits, and I think that these can be traced back to four main demands that climate plaintiffs ask from the court, and what courts are now increasingly willing to give this protection for future generations in various jurisdictions. So what are the avenues with which courts can protect future generations? Now, one of the most prominent avenue is to protect them through human rights. So whereas originally human rights were applicable only between contemporaries, we see in this recent climate litigation wave that courts have started to expand the temporal scope of human rights in order to give protection against future threats. And one of the ways of doing that is to acknowledge the rights of special rights holders, the most vulnerable to climate harm, and recognize their right to be protected from climate harm, such as rights of children. Some courts even talk about rights of future generations, in Colombia, for instance, or they protect the rights of indigenous peoples most vulnerable to the lack of adaptation and the lack of mitigation. And then other sort of approach is to focus on generally applicable rights, that some courts and some jurisdictions, they argue that they would conceptualize future climate threat as violations of generally applicable rights, such as the right to life, right to health, or right to private life held by every individual. And that was the course taken by the famous Lorand decision that I mentioned to you earlier. So the Dutch Supreme Court argued that the lack of ambitious mitigation measures in the present will inevitably lead to harsh climate impacts, such as floods, sea level rise, droughts, and these future risk and future climate threats violate the rights of present individuals, even though these harsh risks may materialize only from decades from now. So in a way, they sort of opened up, they expanded the temporal scope of the rights enjoyed today in order to give protection against future threats. A bit different approach or reasoning was given by the German Federal Constitutional Court in Neubauer case, which conceptualized the possible violation in an even wider scope. So they said that every freedom rights will be put to jeopardy if we don't tackle climate change in the present. But what is interesting that the German court did not reason in the same way as the Dutch court. So did not took the sort of intuitive way of arguing that harsh climate impacts will violate human rights. But they claim that not only harsh climate impacts violate, but drastic and immediate mitigation measures will also encroach upon human rights. And this is an argument for acting today. Because in that case, the German legislature wanted to postpone mitigation after 2030. And the court said that by doing so, you are offloading the drastic mitigation burden on future generations. So basically, the legislature put future generations in a position where they will have to put a full brake on their lifestyle and immediately decarbonize, which will inevitably include drastic, harsh measures such as rationing of food and water, restrictions on individual dietary choices, or even individual means of travel, electricity, rationing. And these harsh measures, which will be necessary in order to tackle the then climate emergency, will necessarily violate every individual's all sorts of freedom rights. So these are the sort of argumentative solutions of domestic courts and also the UN bodies. But another big question for us this year is to see whether the European human rights regime will be able to tackle and accommodate climate complaints. So the Strasbourg Court, the European Court of Human Rights, here these famous climate cases, where the underlying law is the 1950 European Convention on Human Rights, which mentions, which doesn't mention at all climate change. It doesn't even have a separate right to environment. So the question is whether this convention, which contains a right to life and right to private life, can accommodate climate change and climate complaints. Our hope is pinned on the living text doctrine, because the court also announced that it will interpret the black letter law of the convention in light of the changing present-day circumstances. But the big question, whether the court will be willing to interpret the black letter law of the convention with a view to the fact and the increasing realization, which was voiced even by the UN Secretary General, that the climate crisis is in fact a human rights crisis. So the question whether whether the climate complainants will receive remedy for the European Court of Human Rights. We also have to acknowledge and appreciate that these climate complaints raise serious procedural and substantive questions. So they really, in a way, disrupt the convention system. And it is not at all surprising. So legal commentators have long noted that the climate change is a legally disruptive nature. This is what it does. It really frustrates all of our notions that we were using before. So the the European Convention on Human Rights was originally designed for individual complaints. So the idea was that a single individual will suffer harm and will sue its own state. And then the court can give remedy in this particularized relation. But this does not work with climate change. Climate change affects all of us. And the climate harm is essentially global, which is caused by all states. So it will not, it cannot really squeeze into this particularized approach of the convention. So we see that these climate complaints really strain the strict procedural requirements of the convention. And it was clearly visible in the even in the hearing in the Duarte case, in the Portuguese case. As Diane also mentioned, I was involved in this case as a legal advisor to one of the third-party interveners, the European Network of National Human Rights Institutions, which supports the plaintiffs, the Portuguese kids. So this hearing in September was the biggest hearing ever. So there was no similar cases in the past where 32 states were sued. So the whole operation really strained and put an extreme pressure on the court. The 32 states were represented by more than 100 state officials, and there were the 6 Portuguese kids with their family members, and there was a whole NGO which prepared their case, plus 6 barristers that were pleading their case. Not to mention all the spectators, media, and media attention, and journalists and all other experts that wanted to attend the hearing. So even the entry procedure alone took more than 1 hour to go inside the court in an orderly fashion. And the hearing took more than 5 hours. Out of 1 hour, only considered climate science. What is the core scientific basis of these claims, and how can we translate scientific evidence to legal findings in the convention systems? And because of the length of the trial, there was a lunch break, and there was a very intricate sort of choreography of how different delegations can go where, because they were not supposed to meet. So it was a very huge question, which delegation could go to which bathroom, because actually the court building is rather tiny compared to such huge hearings. So the court, not even the court building was designed for organizing such hearings. So you could literally feel that it almost shattered the whole system. But I also believe that the almost is the operative word here, because so a very strong message for me of that day was that the court actually managed to cope with it. So they put it off. It required weeks of preparations and a very strict procedure, but they managed to do that. And I think that this can give us a hope that if could, organize the logistics around this historic hearing, we can have hopes that it will also manage to squeeze climate facts and climate science and climate change into the legal rubrics of the convention. Now the case is pending, so we expect it to have judgments hopefully before the summer. And now we really don't have time to go into the details. But I just wanted to flag the 2 extreme outcomes of the case. So on the one hand, the court can agree with the complainants, right? And they can, and which means that they would acknowledge that all individual who suffers harm from climate change can sue its state, which does not do enough to tackle climate change before an international court, before the European Court of Human Rights. And that would totally fundamentally alter and transform human rights adjudication, but also climate litigation. But our focus should be on human rights. So that would be a transformative change to what human rights means today. But the courts could also agree with the states who argue that these cases should be dismissed altogether. Which would because of course the European Court of Human Rights may not want to become a climate court, so they can dismiss these cases, which would mean that the court is unable to give, the human rights regime is unable to give answer to climate change, which is the #1 crisis in human rights in this century. So that could also mean, which would also be a transformative change in the other direction, that human rights just reach the end of the road. So this is what are at stake here. So I recommend everyone to be on the lookout for the upcoming judgments from the Strasbourg court. Now, another prominent litigation avenue is to develop new duty of care obligations for states and for corporations to care about the future under various legal bases. So duty of care obligations can be discerned from international law, from human rights law, from constitutional law, from common law, from tort law, from company law, all sorts of legal bases. The idea here is that, which is very prominent in the public trust cases. So the public trust doctrine sees the state as not as the owner of the natural resources, but as a sovereign trustee, which must treat and tackle and manage these resources, the natural resources, in trust for future generations. So in a way that they need to always consider the interests of the trust's beneficiaries, who are future generations. And the public trust doctrine is also very prevalent in common law doctrines, but also in constitutional law all around the world. And now it is being picked up by climate litigants. So the very famous Held versus Montana case that you can see on the photo, it was the first success of a youth-based or youth-led litigation in the US last year. They partly reasoned with the public trust doctrine, with the public trust obligations of the state. So the idea is that the state has an enhanced duty of care about the future. It cannot undermine unilaterally the interests of future generations because it must act as a sovereign trustee. And we see such public trust claims pending in 7 jurisdictions in more than 30 cases. Now, a third litigation strategy, which is often which is prevalent in climate lawsuits, is about anti-discrimination. So simply stated, discrimination means the discrimination occurs when a state treats essentially similar individuals differently in an unjustified way. And now in climate, plaintiffs claim that the lack of mitigation action today will create harsh climate futures and will put a disproportionately adverse impact on future generations, which amounts to discrimination and which shall be thus prohibited. And this is the main reasoning in the Portuguese case, in part, which is based on this fascinating yet equally frightening research that has been published in Science and was conducted by Wim Theory and his colleagues, and which now you can check it out on an interactive platform called myclimatefuture.info. So I highly recommend all of you to check it out, because you can set the region where you're from. You can also set your date of birth, and then you will be faced with the truth of what sort of climate future you are bound to face. So the harsh reality is that the later you were born, the more serious the impact is going to be. So for the sake of example, I've set someone who's from Vienna and is 21-year-old, and in 1.5 C world, which is a quite optimistic future. Even in this very optimistic future, you would face a 11-fold increase in heat waves. But if states cannot reach 1.5, which is getting to be more and more likely, and if they will only deliver on their climate pledges, then our world's going to be around 2 degrees somewhere. So in a 2-degree world, the same individual in Vienna will suffer 15-fold increase in heat waves, in a hothouse Earth, not even a hothouse Earth scenario, but like if states fail to deliver on the NDCs in a 3.5 C world, in Vienna, people will be exposed to almost 20-fold increase compared to someone who was born in 1960 and who will not see such extreme harsh climate futures in its lifetime, in his lifetime, or their lifetime. So now the science is very clear, right? The question is whether the court will agree and whether they will be willing to treat these disparate climate impacts as an indirect form of discrimination, legally speaking. The fourth litigation strategy lies in claiming access to justice rights for those who would like to speak for the interests of future generations. So the first question in almost every climate lawsuit is whether climate lawsuits at all belong with the court, because in some jurisdictions, the political question doctrine, the separation of powers argument, still blocks climate lawsuits, mainly in the US. But luckily, outside the US, there is an emerging global consensus that courts can scrutinize climate lawsuits, exactly because inefficient climate action creates human rights concerns, and human rights concerns are matters that are genuinely reserved for the courts, or the courts can have a say in that. Another major question in this respect is whether youth and children plaintiffs can have legal standing, whether they can bring the claim to court when they argue about the future. And even though we see that in many jurisdictions there are procedural hurdles in this respect, still youth plaintiffs are a dominant type of plaintiffs in these cases. So I argue in this paper that if we look at all these litigation, then there is a shared message which emerges, and this is that states cannot treat future generations in an arbitrary way. So states are no longer free. They no longer enjoy an unfettered discretion in prioritizing immediate economic gains by undermining the living opportunities and the future of future generations, because they're now fully aware of such harsh conditions. So knowingly and willingly impose such harsh conditions are increasingly viewed by courts as being arbitrary, and therefore they increasingly run against binding obligations in several legal jurisdictions. Hearing such disputes, however, raise some uncomfortable questions for the courts as well. So how they can define what lies in the interests of posterity, how they can justify that a certain short-termist policy is really short-termist, so it really undermines arbitrarily the life opportunities of the future. And I think that they have two major tools. One tool for the court is to look at the science. So science can help us and help courts to identify what lies in the interest of future generations. But it is not at all simple. So we don't have really time, again, to go into the details, but I'd just like to acknowledge and flag here to you that using science in the courtroom is actually very tricky, and it is not without its difficulties. And actually, international courts have a quite long and bad track record of circumventing science in many, many ways. But in climate lawsuits, I think that the situation is a bit better. So if we look at climate judgments, there is an almost obligatory reference to IPCC science, usually among the relevant facts of the case, or when they are mandating the required level of ambition with which states must design their GHG emissions reduction targets. A major question now is whether courts are equally willing to use attribution science. Now, attribution science tries to causally link a certain particular adverse weather event, such as a typhoon or a landslide, back to climate change. And for decades long, it was thought that science cannot help us, science cannot make such causal assessments. But in the last 5 or so years, there seems to be a major breakthrough in attribution science. So attribution scientists now claim that they're able to do so. So check the World Weather Attribution website out if you're interested in. You would see a fascinating body of research where scientists actually are able to quantify how much more likely did climate change make the occurrence of a specific adverse weather event. So by combining observational data plus new climate models, climate attribution scientists are now able to make some overarching and scientifically robust statements whether a certain weather event was made more likely by climate change. So for instance, they claim that climate change made the extreme spring temperatures in the southern Mediterranean last year at least 100 times more likely. And the question now whether courts will accept such scientific assessment as a basis to draw and establish causation, legally speaking, as well. And this is the question in the pending extremely interesting case between a Peruvian farmer and the German electricity provider RWE. So the applicants are living in the Andes next to a glacial lake, the volume of which has grown 30-fold due to global warming. And they try to defend their village against such climate threats by erecting a wall, but they don't have the necessary money to do that. So now they're suing the electricity company RWE. And the argument is that the company contributed to gross GHG emissions quite substantially. They are responsible for 0.45% of all GHG emissions. So the argument is that the company should pay the same percentage of all mitigation costs, or adaptation costs rather. So the 0.45% of the cost of erecting that wall. So again, here the court will be asked to look at attribution science and draw some legal conclusions. The first instance court disagreed, so they dismissed the case. But in the second instance court, found the claim plausible, and now they enter the evidentiary phase, and then the judges just paid a site visit to Peru to visit the village in question. So we shall see how it will play out. And there's another very fascinating research just published in Nature Climate Change last year by Rupert Stewart Smith and his colleagues, and they claim that the reason why such claims didn't succeed in court is that courts were not presented with cutting-edge science. They were presented with old attribution science. So we shall see whether this is really the problem, and whether when court of law is faced with new, the cutting-edge attribution science, whether they will be willing to establish a causal link in a loss and damage claim, and whether they will be willing to hold individual emitters accountable for the climate damage. The other tool, which I believe that court has in justifying that they protect future generations, is to refer to soft law documents. Now, soft law documents are non-binding instruments, so they are emphatically designed to be only political commitments, but not legally binding commitments. However, we see that in climate litigation, courts do look at such soft law instruments, and then they impose binding obligations on emitters. So this happened in the Shell case, where the court, the Dutch district court, when it ordered the Shell to cut emissions, it basically argued on the basis of a soft law document, the UN Guiding Principles on Business and Human Rights. So knowing that many of you are studying environmental policy and may be involved in the future in negotiating such soft law instruments, my message to you is that never underestimate the legal power of a non-normative instrument, because later on they can have huge normative implications, even though they are not binding at their inception. So lastly, I'd like to summarize my main messages, why I believe that that using this narrative focusing on future generations is really a powerful one. So first of all, I think it's a powerful message because we see that courts are now increasingly willing to use this language and develop intergenerational dimensions of binding obligations, but it also captures the imagination of the wider public. So it is picked up by social movements, by media. So it really spurs and catalyzes social discourse. And I also believe that this can be really one of the solutions that we need. So the idea of intergenerational equity, if taken seriously, can really help us fill this void in the legal responsibility. So it can really help us develop a sort of future-oriented body of law, which is capable of allocating responsibility for causing harm in longer timescales. And as in his very enjoyable essay, Jorge Viñuales argued back in 2018, this can be one of the major solutions that we need. So in order to find a way out of the Anthropocene, we need to rectify this gap in the legal paradigm. We need to have legal rules governing the responsibility for inflicting harm on longer timescales. And we see that climate litigation attests that courts are increasingly willing to inject long-termism into the traditionally short-termist decision-making paradigm. And also they are willing to limit state discretion to the extent that they not allow states to undermine arbitrarily the interests of posterity. And I believe that this can have, on the long run, a transformative impact, because as soon as states realize that the fact that their short-termist policies will not fly in court, it has become a much more burdensome and less successful endeavor, then it can have a real deterrent effect of adopting such short-termist policies. But we also have to note that legal innovation studies warn that in order for innovations in the law to work, they must be marginal, they must be incremental. Now, this may sound in contradictions in terms, right? How a solution can be innovative and at the same time marginal. And this is because it seems that revolutions just do not work in law. We have to appreciate that law is a very conservative exercise. It values legal certainty, it values predictability, it values overall adherence to past commitments. And this is why, on the long run, only those innovations will succeed that are incremental. So what we need is to find something which is deeply anchored and rooted in existing legal doctrines, so the execution of which is incremental, yet which can have a transformative impact. And I think that intergenerational equity can do just that. because as we've seen in these concrete examples, it allows courts to reason in a way where they're using well-established legal doctrines. They're using human rights doctrine. They're using duty of care obligations. They use anti-discrimination policies, which are very, very well established in domestic laws, and yet they can also develop intergenerational dimensions for these obligations. And a further proof for that is that, as I argued to you, this is all about arbitrariness. This is all about prohibiting the arbitrary treatment of future generations, and the prohibition of arbitrariness is actually a core guarantee of the rule of law, and the rule of law is the backbone of our legal systems. And this is why I think that reasoning with future generations' interest, if tied to these well-established rule of law guarantees, can have a reason for realizing a transformative in fact, it can help us reimagine the legal order in order to be responsive to future threats. Now, some final words on the future, what we can expect from future generations. So this year is undoubtedly will be decisive. Major international courts will announce their judgments on climate mitigation. We also have to acknowledge at the same time that climate mitigation is not a panacea, so it will not solve all our problems. It is part of a larger endeavor. I do believe that it does have an important role, but we also have to appreciate that legal proceedings take a long time. The question of implementation and compliance with the judgments is a crucial issue. Nevertheless, I believe that these court proceedings do have a role to play, but we cannot pin all our hopes on climate mitigation, basically. I see climate lawsuits as part of a larger attempt at rewiring the legal system. I think we have to appreciate that climate lawsuits evolved in a very iterative way, so on the try and error basis. For some arguments may not fly, or may be unsuccessful at first, and later they may succeed. Some may be permanent dead ends, and sometimes we need to lose a case first and then use this some good sentence in that lost case in order to build a successful case later on. So this just happened in Norway, that a few years ago they lost the case, and then they took the companies again to court, used a bit different language, they relied on the previous case, and now they've won before a different court. But still, so I just want to emphasize that don't lose hope. Sometimes we need to lose the case, or if we lose a case, we could prevail later on. And also, I think we have to acknowledge that where there's progress, there's backlash. So just in the wake of these innovative and strong climate judgments, major emitters started to sue climate scientists and corporations and NGOs. So started to sue NGOs and climate scientists with defamation lawsuits. So we must rest assured that the road ahead will be bumpy, but I think it offers hope that that the climate change litigation has come a long way since 2007, when the first international climate case was dismissed altogether briefly because they said that there's no evidence. It's not scientifically speaking. It's just cannot be legally speaking. It just cannot be established. And my last message to you, because I know that many in the audience are not lawyers, that climate lawsuits is just not about lawyering. I do believe that in order to make a successful case, we need insights from several fields of expertise. And this is why I'm almost willing to bet that many of you later on will be involved in such cases, because in order to make a successful case, we need to reimagine legal responsibility, for which we need some insights from philosophy, from moral philosophy, from psychology. Actually, we need expertise which covers the dynamics of social movements, or how to build a successful social movement. We need expertise from good communication, transformative governance, and policymaking. And all of these types of expertise have to be woven together with cutting-edge climate science, which is undoubtedly a challenge. It's true, genuine interdisciplinary nature of the field. It can be challenging, but in my view, for someone who's trained both in natural sciences and law, I think this is one of the greatest beauty of this field. And now I know that my time is up, so I'd like to just thank all of you for your kind attention, and I'm really highly anticipating all your questions and comments. I just want to briefly flag that if you're interested in these matters, then stay alert and look out for an upcoming special issue in the journal Transnational Environmental Law, which will feature a special issue edited by me as a guest editor, which will concern these issues, future generations litigation and climate litigation. And thank you so much. Sorry.
Thank you so much, Katalin. That was quite a mouthful. So definitely, I have tons of questions. I will have to hold myself back to let everyone else ask questions. But before that, we are really privileged to have a discussion today. So I'm very happy to introduce you to you. Many of you already know her very well, but those not necessarily who are watching us online. Karen Lucas is a professor, visiting professor at the Legal Studies Department of the Central European University. She works on how to translate human rights and business issues to environmental legal matters. Also, she has been working on these matters with the World Wildlife Fund. She has worked over 20 years in human rights, and she also was head of department at the Ombudsman Institute before. She has also many other accomplishments, but let's instead listen to her commentary and on her discussion of the Katalin's lecture. Over to you, Karen.
Thank you very much. Show my microphone. Yeah, thank you very much for this invitation to give a short comment on oh wow, okay, this is the self executing PowerPoint, which was not the intention at all. So let's try to get back here. Okay. Do not touch the board, that's the thing. I'm very happy to provide some comments on this really very dynamic field of climate change litigation, which reminds me it has striking similarities to the strategic litigation that we saw in the 90s and the early 2000s and going on against corporations for human rights abuses that they were accused of participating in. And also with, at that time, we had discussions of why do corporations have human rights responsibilities? These are state duties. So the responsibility, to cite one economist, of businesses to make business. And that's the only responsibility there is. So similarly to climate change litigation, there is an accountability gap that we see, and that civil society, NGOs try to address inter alia through litigation. And contributing to, Katalin has already given a very, very interesting data here, but sort of contributing here is where is the climate change action in terms of national, regional, international level. And here you really see in yellow the vast majority of suits against states and companies is still on the national level, on the domestic level. So this is where the action at the moment still is. But also, interestingly, we have two regional courts where there are lawsuits that are brought. And this is the Inter-American Court for Human Rights here and the European Court of Human Rights. Katalin already mentioned some very groundbreaking issues we're going to see. And less, but a little bit before the UN bodies. So we have, for example, one case before the UN Committee on the Rights of Children, before the Human Rights Committee, so also a little bit here at the international UN level with the monitoring bodies, human rights monitoring bodies. You see a movement there, pressure being exercised there. One of the reasons why we have the majority of cases before domestic courts is that more than 150 states by now have in their constitutions a right to a clean, healthy, and sustainable environment. So every citizen of that state can, and it's been done, say my constitutional right to a clean, healthy, and sustainable environment is infringed. So I bring this to court. So this is, I think, one very, very important aspect, that the right to a clean environment is constitutionalized. So we see more and more constitutions incorporating this aspect. So now really to the next slide, not just the system doing. It's a very basic principle where there is no plaintiff, there is no judge. So what is really interesting and really impressive, groundbreaking about the climate change movement is the extreme amount of activism, of mobilization that climate change has generated. I mentioned just one activist here, Chai Surui, who is one of 6 young activists that actually brought a lawsuit against, at the time, the Bolsonaro government for Bolsonaro government changed the baseline commitments committed to in the Paris Agreement, and here before the International Court of Justice, this suit was brought, at the international level. And linked to that, another example is that in France there was this case called Affaire du siècle, so affair of the century, where before NGOs brought a court suit against the French government, saying that you have not fulfilled your commitments that you brought, that you committed yourself on the Paris Agreement. This was actually preceded by a huge online petition. So unprecedented in French history, over 2 million people actually signed an online petition urging the government to fulfill its commitments in the Paris Agreement. And then the government did not budge, and then these NGOs brought the Affaire du siècle case, and with a good outcome. And I will get to that in a moment. So there are also, regarding the intergenerational aspect, I think there's one decisive point. And that is that in the right to a clean, healthy, and sustainable environment, the intergenerational aspect is inbuilt. It's incorporated. So if we talk about the right to clean, healthy, and sustainable environment, we need to think about future generations. It's inbuilt into this concept, into this term. And as early as, you see that in 1996, the International Court of Justice already defined the environment as including generations unborn. So already in the nuclear weapons advisory opinion, there was, by the International Court of Justice, reference to the future generations. So it's already there. And domestic courts have started also to take this up. So not so much in the European system, which I think is a bit behind with those more progressive aspects. But for example, the Supreme Court of the Philippines in the Bosa case, this case was about the drastic deforestation of the Philippines rainforest. So at the time of the judgment, and this is why also science is so important, and the facts, it was very clearly brought to the Supreme Court that that the Philippines had roughly 53% of rainforest on the archipelago. And by the time the judgment was rendered, so that was in 1993, there remained 4% of the rainforest. So drastic commercial logging that was going on. And the Ministry for Agriculture was actually the one that was being sued, was a defendant, and it had already issued a huge number of logging licenses. And here it was also clear from the prognosis that should these logging licenses be implemented, then within a decade, the Philippines would be left of any rainforest. And here, the Supreme Court of the Philippines stopped this licensing agreements. So it was a very groundbreaking judgment. And it also referred to this aspect of intergenerational justice and intergenerational responsibility that the state has in order to fulfill and guarantee the rights of future generations. Yeah, that's my last slide. Also sort of conversing a little bit with what Katalin has been saying. So we see in many of these court cases that the state uses the separation of powers defense. So it says, well, the policies, the projects, the financing regarding climate change commitments, this is something that is in the policy. This is what the state has to do and does. This is not something where the courts can interfere. But this separation of powers defense is a defense that is gradually being rejected by the courts. So we see a weakening of this type of defense, mainly, in my opinion, because, again, of these international legal commitments that were undertaken by states in view of the Paris Agreement. So we have, Katalin mentioned the agenda case, also the affaire du siècle case, clearly sets out the state has undergone these commitments. It has legally bound itself to implement these commitments. And this can be reviewed by the courts, and this can be monitored by the courts and checked. So this separation of powers defense is really weakening. Where the courts still appoint state discretion, and this is really a legal principle. I think this will be difficult to overcome, but maybe it's also not necessary, is a discretion regarding the details of the implementation of the commitments. So the courts say, well, you have to do it, you committed yourself, but the details of how you do it, okay, this is still within the realm of the government. And policies and details of implementation. And then lastly, Katalin also mentioned it, and I refer back to Chai Surui's statement, the earth tells us we do not have much time. And the law is slow. Court cases take time. So it can only be one tool in order to exert pressure on governments to do something more. But I also think it is a powerful tool. We have seen already that the law can adapt. The living instrument doctrine, we saw it with the human rights of corporations. That was unthinkable 2 decades ago. Now we have them in court being sued for human rights abuses. So the law is flexible. It can adapt, and it needs to adapt to this, in my opinion, #1 human rights issue. So, and we see, and this is, I think, something that I want to end on a positive note, we see that civil society, NGOs, can exert huge pressure on states through court proceedings, and we will see more of that. I'm not so pessimistic regarding that the human rights road ends because of the European Court of Human Rights. I also don't know how they're going to decide it, but I was when I was with the European Committee of Social Rights, we had regular exchanges of view with the court. And here it was very clear that the court is very, very aware of the urgency of the problem, of the necessity to say something. And it also prioritized the Duarte Agostinho case. So it really assigned it a huge priority. What then in the details of the judgment is really going to come out is of course difficult to predict. But I think there is a huge potential in it. And there's also the Inter-American Court, other regions where there really is an advancement through climate change litigation. With that, I thank you very much. And I also look forward to the discussion.
Thank you very much. Well, that was super interesting. And then we heard even a slightly different position, which gives it even more interesting. Maybe a bit more hope that maybe if there is a negative decision, everything won't be lost, which certainly we didn't believe. But also you both have mics. Perfect. Very good. So any questions, comments to any of, or in general to both of our amazing lecturers? Yes, please. Also, if you can first introduce yourself and then take your question.
Thank you, Kati, for the engaging presentation. I'm Zsolt Körtviesi, a postdoctoral researcher here, and so I would like to push you a little bit on 3 points, because at some level it seems that the most important thing that we see is that these cases are happening, taking place and shaping public discussions, and yet there seem to be certain elements, like when you emphasize the impact. I was wondering to what extent it matters, and this is my first question, whether these are damages cases, so with actual material impact. The second is the role of numbers, so to what extent it matters that you see actual people, so not just kind of an institutional or actio popularis challenges, but you see kind of the new generation. Is it just kind of illustrative and for media purposes, or do you think that there is something for law to, especially in cases of aggregated challenges where you bring together more and more people? And the third question is somewhat provocative, but you also raised this, that does it really matter whether you actually win these cases, because the immense media attention probably partly achieves the ultimate goal? Thank you very much.
Thank you.
So can we respond?
Yes, please.
Thank you so much, Zsolt, for the questions. So first of all, damages case is definitely one of the battlefronts that is currently emerging. So thus far, mainly so-called systemic mitigation cases were successful, where the lack or the ineffective mitigation measures of the state was challenged before the courts. And then the second wave was about corporate climate litigation. And the third wave is the loss and damage cases. So far we don't have major successes, but I wouldn't be pessimistic either. So 10 or 15 years ago, nobody would have imagined that we will have huge mitigation cases and huge wins in mitigation cases. So just because we don't have successful cases in the loss and damage, it doesn't mean that in like 5 or 10 years time we will not have any. So
does it matter? Does it matter that my damages cases?
Yeah, I mean, I think it sends a very powerful, huge message to emitters. I think so. Like corporate emitters mainly care about, or think that they care pretty much about whether they will they can be held personally liable for the damages, because the climate damages is astronomical. So and this is why the Fair-Ducier Act was very important, because then the French state was held liable for not implementing its own measures, and then the NGO were claiming compensation for the ecological damage caused by that lack of mitigation action. And then the court awarded a symbolic amount of €1. But it's a matter of valuation. Of course, this €1 did not even aspire to capture the whole extent of the ecological damage that can happen due to climate change. But first we need to establish this causal link, and needs to first establish in legal doctrine that it is possible to hold liable someone for the climate damages. And then a separate question is the valuation. And so I think it does matter, because so far these were more like pro-regulatory cases. These cases, first and foremost, obliged the court to act to mitigate. But it's an entirely separate question whether we talk about financial liabilities. I do think that they matter, and I think they will come. So these cases could be won later on.
And I agree with you. They're coming already. And I think they, especially with corporate actors, they will make a huge difference, because corporations calculate. They say, okay, this is my gain, this is my loss. They already calculate damages because of losing lawsuits into their budget. So it will be for them. This is damaging in terms of change for corporations to do things differently. I think this is a huge tool.
So hopefully just a matter of time. And as to your second question, is there a real mass of people, right, behind these cases? Yeah, definitely. So of course, there are youth plaintiffs in the first place, but also these cases are usually brought by several NGOs, and sometimes these NGOs represent masses of people. So we didn't have time really to go into the fascinating Swiss ladies case before the Strasbourg court, where the NGO comprises more than 2,000 Swiss ladies aged above 70 years, who claim that not only children will be harmed by climate change, but also elderly women, because the science is also clear that heat waves hit elderly women disproportionately worse. So so we definitely talk about masses of people. And yeah, the Duarte hearing was attended by hundreds and thousands of climate activists. And yeah, I think on the meta-juristical level, so a meta-legal level, I think the court does care about the sort of the social attention. So you could definitely feel in the room where, in the Grand Chamber, which was packed with people, and they had to open another room because there were so many attendees that there were two big rooms filled with people, and then there were massive protests on the street. So when you approach the building, there were protesters everywhere, and of course it does have an impact. So I guess every judge, have an eye for the social atmosphere, and it definitely, I think it does count.
Did you want to add anything, Karen?
I think this is so closely connected between really mobilization of people through online petitions that then lead to litigation, and courts, as you say, courts are aware of who brings claims, is backed up by 2 people or 2 million people. It does really make a difference.
Thank you, fantastic. I think there was a question. Sweta, did you? Yeah. Sweta. Oh, there are many questions, so maybe everyone can hold just shorter questions, and maybe I can ask short answers so that we can get to more people. Thank you.
Yes, so first, thank you very much both. It was super interesting. My first question is basically around using different approaches to push these kind of cases, and your experiences of which ones are working better than others. For example, either using the right for a clean, healthy environment, or human rights framework, or the duty of care, every freedom rights. Like, between all of these, which ones are working better than the others, and maybe why? And I also had the question, now that human rights and environmental justice and environmental law are trying to evolve to be more broad, are they considering, for example, to bring traditional knowledge to make it more inclusive, and to actually bring all these populations that are generally marginalized or not really considered? Because in the end, their take on nature is way better than our general take on nature. And yeah, those are my 2 questions.
Well, wonderful, thank you. So if I give a go. So first of all, I think short answer is that there is no one-size-fits-all solutions. I think this is why future generations litigation is highly experimental, because you cannot know which exact avenue would work in your jurisdiction. So some jurisdictions, human rights language works well. In others, we need to talk about duties, because somehow, courts are not so super excited about human rights language. So I mean, it really depends on the time and culture, on the jurisdiction that's where you are. So this is why we see that the climate community is really, and I think it's a wonderful thing, it's very, very diverse, because you need legal experts from that very country, and they know best what may work. And then the other thing, so indigenous peoples and indigenous legal cultures and indigenous cultures in general are highly important, and not only in environmental protection, but they also know more, or they also know better how to protect future generations. So like the idea of intergenerational justice is really deeply rooted in indigenous legal cultures, and we see that actually those countries where there are massive populations of indigenous peoples, they do reason with future generations. So like in the global south, the future generations language is really really powerful before the courts. So that would, if you're interested, we can talk about later on, because there's a very interesting study which is recently published by Margareta Weber-Gesing, and her co-authors are looking exactly at that, and how this future generations discourse is not just the Western discourse, but it is perhaps it was even present in the global South before the global North. So it is, I think, it's another very powerful feature of this discourse, that it can be present in every legal culture.
So the right to clean environment was pushed first in the global South, then in the global North. So it was really a different avenue that was taken, and then the global North sort of joined. So totally. And the which is the most effective? It's a tricky question, because also the question is, what do you want to pursue? So, for example, if you want to go against the greenwashing of corporations, you may want to use misleading advertisement laws. If you want to go against or for climate change action of states, of corporations, maybe you go for anti-discrimination, human rights. So it really depends on what you want to achieve, and then use these different tools that you have.
Fantastic, thank you. Please also introduce yourself. No, please, no, because there is online streaming. So.
I am Maciej Kizlowski. I teach law and strategy here, and that's why I was very interested in your talk. Now, from a strategic perspective, I got your point about the counter-majoritarian aspect within democracies, yes, and the short-termists. But your own experience, as Diana mentioned, comes in large part from a non-democratic country. So I wonder, what do you see? Do you see a strategic role of climate litigation in hybrid and autocratic regimes like Hungary? And of course, Hungary is small, but similar regimes are much bigger emitters. Yes, Russia, Turkey, China. So if you can comment on that.
Definitely. So, for instance, we do have a climate case in Hungary pending, and it is not rooted in human rights law, but it's rooted in the duty of care obligations, the public trust doctrine. So I think that duties, if you can found in a source of law from which you can discern an obligation for the state not to harm the future, that can help. And in this respect, on paper, the Hungarian basic law is quite ambitious, because we do have an obligation in there. Article P obliges the state, actually, which is very good for us. It obliges not to harm the interests of future generations. And the court also announced that they believe that this article embodies the public trust doctrine. So now we can drag the whole transnational jurisprudence on the public trust doctrine before the court and try to argue that then it means that you cannot harm the future. So we shall see how far we will go. But I definitely would not try the human rights language in this. In such jurisdictions. I don't know about the Chinese experience, but I know that there are also some bugs that are coming up. So I would just refer back that we need some local legal expertise to know how we can really shape the legal paradigm. I also believe that I think short-termism and government discretion is sort of everywhere. So this is all about the Anthropocene legal governance, that the legal systems maximize the benefits for corporations to make profit, and I think it's a widespread phenomenon. So the tools to abate this systemic failure may be different, but the root causes I would bet that they are quite similar.
Did you want to add something?
No.
There was Mila.
Hi. Thank you so much, Professor Dan, for organizing it, and Katalin and Karina for presenting such insightful information. I have 2 questions. So first, as we know, in Rome Statute, there is no environmental crime force article. And I wonder, how it can be used, in what forms, if it will be reinforced in Rome Statute, how it can be used in this future generation narrative. And second question, what, like, do you envision potentially that European Union, like on the European Union level, there will be some law which will be reinforced regarding these rights of future generations? Because as for now, as I know, there is no such law, and what potential steps could it be for such a law? Thank you so much.
Thank you for these wonderful questions. So, so first about the ecocide, yeah, there are attempts to amend the Rome Statute with a new form of international crime, which would be ecocide. And yeah, the roads to get there is quite bumpy. But if it's successful, then I guess there could be possible synergies with the rights of future generations narrative, because I think what they have in common is that they both want to, steer the legal system away from this strict anthropocentrism. So ecocide would make it an international crime to knowingly and willingly destroy nature. So of course it would not give a personhood to nature, but it does try to steer away from this strict anthropocentrism, and then in this way there can be some synergies or like shared philosophical grounds with the intergenerational equity discourse. And yeah, the EU is another fascinating question. Yeah, at the moment there is no strict legal obligation binding on the EU to guard and consider the interests of future generations. But I also believe that if they look, and we just recently released a report on that, so you can check it out. It will be launched next week, exactly, on that matter. So if you look at the Treaty of the European Union and Treaty on the Function of the European Union, so the basic treaties, you would also find many hooks on which you can argue that if there is political will on part of the EU institutions, then they can pursue a much more ambitious agenda. There's a goal of sustainable development. There's the solidarity between the generation principles. There is the Charter of Fundamental Human Rights, and then so there are many legal hooks which, if there's political will, then can bring about a transformative change. But the treaties, as stand today, they do not pose such an explicit legal obligation. But there's so much room for maneuver to use the existing obligations, existing goals to make much more future-oriented policies. But of course, if you want to achieve a very strong protection, then you may want to amend the founding treaties. But there's also a very important campaign which will be launched next week, for which I prepared this report. And so the ultimate goal of this campaign would be to create the spokesperson for future generations on the level of the institutions. So that if it's successful, that could be a real game changer. So there are several institutional ways of doing that. We can talk about it later on. But I just wanted to flag this to you that there are ongoing efforts of transforming the EU as well and make it future-proof.
And there is in the UN in the Charter on Fundamental Rights of the European Union a right to clean. So it's already there, but it needs to be used more and better. And regarding ecocide, there is, for example, there are quite substantive initiatives within the European Union. So there is a good study by the European Law Institute in how to implement ecocide considerations into the European Union legislation. And regarding the ICC, I mean, yeah, if it comes, it will take time because states have to agree. This is always a very lengthy process, but still it exerts pressure on states to engage with this, to take positions. And for example, Philip Sands has interesting research on ecocide and also others. So there is quite a lot of pressure that is there for this ecocide concept.
Thank you. Now we have kind of run out of time, but why don't we just take every remaining question quickly and let's see a very quick, few second answers collected. So yes, two more hands.
Hi, thank you for the presentation. So I was actually wondering, because we talked about the 33 states that are being sued by Duarte, and I was wondering how feasible is it actually because of the issue of the exhaustion of domestic remedies. So because this was also the issue with the Saatchi case in front of the Committee of the Rights of the Child. I was just wondering how you would think it could be bypassed, maybe, this issue. Thank you.
Shall we collect, right?
Yeah, we are collecting. Yeah.
Well, thank you again for the presentation. I was wondering about the huge cost and resources that is needed to develop to have this climate litigation in all the countries, because I used to work in one of this NGO that used to make this kind of suit about oil spills in the Amazon, and the resources that we needed just was a lot, and also the oil companies had the resources to pay huge firms of lawyers, international lawyers, and everything. So I was wondering if it's possible, if you have seen cases of the democratization of climate litigation that bring this concept more close to people, because it takes a lot of money and, well, basically it's kind of difficult for the ground people to get to know about this. Thank you.
And if I may close the number of questions from many questions, I just narrowed it down to one, because most of your discussions related mostly to the right of a healthy environment or just rights of human rights. But to me, one of the biggest issues, intergenerational issues, is, although Katalin, you alluded to a little bit to that, is that the vast majority of net zero commitments rely on now doing very little and then at the end taking huge amounts of the obligations of taking gigantic amounts of carbon dioxide out of the atmosphere. And we know that these are probably going to be very expensive. And also we are talking about billions of tons each year, even if you take it down to almost per capita level, that's still substantial. So it's still a substantial cost. And this has to be done then every year afterwards, as long as we are emitting anything, or even if we don't emit, it's still, we have to do a lot of negative emissions, even just to compensate for our delay in action. So that means that it's also very unjust, because future generations we are committing them to pay, because a lot of these net zero commitment are kind of in the legislation, right? At least in many countries. So is that not an angle from which present generations could sue, that they will have to pay for our luxury? Is there anything on that? Anyway, so why don't you go ahead and quickly tackle these three questions?
So very, very short answers to the wonderful questions. So first of all, the duarte case. Yeah, of course, there are major procedural questions. And then, one of them is the exhaustion of domestic remedies. But, domestic remedies only need to be exhausted if there exists an effective remedy. And one of the arguments of the applicants is that there are no effective remedies at domestic levels in many of these member states. And one of the reasons for that is the urgency requirement, So even if there is a procedure which would be available for Portuguese kids in all these member states, let's assume that there is, I think there are good arguments to be made that there may be none. But even if there is, if they try to exhaust these remedies, that would take 5 to 10 years. And we don't have that much time. So that was one of the compelling argument that the court should make an exception, because there is such an urgent need for action. We cannot sue 32 states individually in 32 different procedures, because then this question will never reach the court. So that is a short answer. And I also believe that this question only comes up in the Duarte case, but not in the Swiss ladies case. So it's also possible that only one of these major cases will survive in Strasbourg. But we can talk about it later on. And other very good question about funding. Yeah, it is also now increasingly appreciated that there's a huge imbalance and huge inequities in terms of access to funding, and even there is a risk when you receive funding as an NGO or a social group, then the funder may have some expectations. So maybe you would like to. You do that want to settle because you want to lose this case, because you think that strategically thinking it's even better to lose the case than not having this case altogether. But your funder may disagree, and they said, okay, let's settle. And then there can be very tricky questions here. And it is a huge problem that there are huge inequities in access to funds for this. So I think now there are some crowdfunding initiatives, and then some bottom-up approaches. Several NGOs try to pool resources together. But yeah, it's a major problem. And I'm not sure I have the right answer to your question, Diana. I need to think about it further, but definitely I think this can be one of the harmful path dependencies which runs against the core idea of intergenerational equity. So one of the main tenets of intergenerational equity that we cannot put future generations on path dependencies because that would violate their all sorts of freedom rights. So I think your hypothetical, not so hypothetical case could be argued based on this principle that we cannot put in a position of future generations where they need to spend enormous amount of money just to keep up with their commitments to live in a safe climate.
Yeah, I think that's quite arguable legally to do that. We will need to see the case and how successful it's going to be. But then there are also cases that really say, for example, the agenda case says, well, the Netherlands had committed themselves to, at the time, so before already, on the 25% reduction. They have failed, so they need to repair that damage and then commit themselves to what they have pledged to do in order not to leave this to future generations. So already there are, not the majority, but there are some courts that really take this into account, that already for sort of damage done because of inertia, the government needs to do something to repair the damage. To the funding and the inequities there, what is interesting about strategic litigation is that you try to win a case that has implications for many people, also those that cannot access formal courts because of costs, because of legal language, because of those intricacies of the court system. But then it's ergo omnes. It's also applicable to the situation that they face, even if they do not have had the means to sue in court. So this is something I think that is empowering in a way. Yeah.
Well, thank you all very much, because this was really a fantastic evening, even on this wonderful Friday afternoon. So thank you all for being here. Let's give a big clap to our presenters. And now I would like to invite everyone in the next room for a little wine and cheese reception, and with some other snacks. And if you stay a bit long, you can even get some Mozartkugels. Thank you.
That was very